Welcome to this video. Actually, this is based on mostly recent case law related to intellectual property. There's one or two cases from the past, but much of these cases are connected to very recent developments in law, or rather case law related to intellectual property. And quite a number of them might be linked to AI, artificial intelligence as well. So let's take a look. First one is an old one. The case is Whitmill versus Warner Brothers. Actually, the case settled out of court connected to a movie which you may have watched. We talk about that later. Take a look at the wording, please. So it was a work by Victor Whitmill, a tattoo. The Warner Brothers, in a movie called Hangover 2, they were accused to have duplicated that particular tattoo that was originally made for, or originally painted on the rather very famous boxer Mike Tyson. Then what transpired thereafter was Whitmill took action against the Warner Brothers. But then Warner Brothers fought back using the defense of parodying. What's mean a parody? Fair use. You can make fun of another person without hurting that person, and when you do that, you can utilize his ways, his behavior, his mannerisms, and all. It's all right in movies and art. So Warner Brothers said we are just parodying on Mike Tyson by using the tattoo as well, but the court wasn't willing to listen to that part of defense by Warner Brothers. And the other thing was, court was rather reluctant to punish Warner Brothers also by cancelling the movie. That would be rather unfair, in the judge's opinion. So the parties settled the case out of court. So even the artwork, such as something as even as small as a tattoo, that's what you see here, copying on Mike Tyson's tattoo. I'll show it earlier. This one, this is original one, and this is copied by Warner Brothers in their movie. So distinct similarities are there, and the artist wanted the movie be suspended, movie to be stopped. The courts refused, so the parties had to settle the case. Not so small amount, I guess, out of the court. So this is what US Copyright Office require when you look at fair use. That means the right to use somebody else's creation, someone else's work in my own work. There is a thing called the fair use. It's a defense that I could use. Take a look at the first one. Yeah, it should be not commercial, for non-profit or maybe educational purpose, right? Second one is how the copyrighted work goes about. Third one, so is it a violation of the entirety or just part of the work, like here the cartoon or the tattoo? And what would be the the effect of the use upon potential market for value of the copyright work? So this is kind of legal jargon, so I'm putting it in a very simple way. So what could be the effect of the final product from this by taking this copyrighted work? So this is a mundane small act in a larger movie, so the court was willing to be still punishing Warner Brothers but not willing to stop the movie. So it was, court was not considering it as fair use by Warner Brothers also, because it was not exactly a non-profit or education work. It was kind of there was a commercial angle in it, but the damage, the court was of the opinion, should not be taken as too serious to stop the movie. And then moving on to something far more different. All right, Frappuccino versus Freddoccino. This is a very recent case between two companies, Starbucks, of course, we all know about it, and coffee culture. Starbucks has a brand, sub-brand or a mini brand called the Frappuccino. It's kind of a beverage made. It's a coffee drink. They name it Frappuccino. Their sub brand was that. But then coffee culture came up with a product called Freddoccino, and that's what you see here. Pretty much similarities are there, right? The case was filed in 2016. Case ended in 2023. And what did the court say? Yeah, that coffee culture was violating having a product name very similar, deceptively similar to you know okay Frappuccino of the Starbucks. So the coffee culture changed the name to Freddo finally. So that kind of false advertising, we call it the trademark dilution or deceptive practice, could get court interested in the case. There have been few cases that in the previous video also you would have found out where the McDonald has taken action. So there was this trademark infringement suit against brownie chips, right? And then there was another one where Starbucks actually lost in the final appeal, where the case was in South Korea, against the Erbria company. See, there are distinct similarities, but there in this particular case, the court was willing to go in support of the defendant here. But see the similarities here also. But here it's kind of very much there is a connectivity between the Freddoccino and the Frappuccino. And even the size, the shape, the logos in the cup, and also there are deceptive similarities involved. So there have been cases where you lose as well as you win. Look at this case, a very interesting case. There was this, can we give intellectual property rights to a monkey or an animal for that matter, a non-human? The story is that there was this personality called David Slater. He just happened to misplace his a camera in the wild, and then a monkey in Indonesia, I think it's a baboon, right? Yeah, he happened to take a photo out of it, and that's the photo you see. So this is a photo taken by the monkey himself, right? So the camera owner, David Slater, later recovered the camera, and then he found this particular photo, and then he demanded copyrights for this particular photo. See what happened? Yeah, 2016, the district court judge dismissed the case, ruling that if Congress and the president intended to take the extraordinary step of authorizing animals as well as people and legal entities to sue, they could and should have said so plainly. That means you can't give intellectual property rights to a non-human. So David Slater couldn't get the right because it was not a photo taken by him, it was a photo taken by an animal. So the animal cannot be given copyrights. Sorry. So the case happened in 2011. It went on to 2014, and the case went until 2016. So Naruto is an animal, not a human, could not establish statutory standing order under the Copyrights Act and determined that it was unnecessary to reach the question. Yeah, that's the thing. So even today it stands, but this will have repercussions on artificial intelligence generated works, right? Artificial intelligence is also non-human. Could such work be given intellectual property rights when a monkey is not given one, another non-human, right? So this will be a challenge. Already it's been challenged. Take a look at this one. So this was a picture created by an artist called Lee in China. He uses multiple prompts to create this the picture called Spring Breeze Brings Tenderness. That was a name that he put for the work of art. You can call it a work of art. But then when he claimed copyrights for this, there was an issue. This was AI generated work. So, for the first time in the world history, a Chinese court decided, take a look at the reading. AI work is copyrightable. The court's angle was that plaintiff has, that means has used lot of his input, lot of his involvement in the making of the work. So he called it as, court called it as AI assisted work, where the plaintiff has exercised aesthetic choices. The story says that he used 64 of prompts, that means commands to AI to create this particular picture. Because of that, the Chinese court determined that, look, he should be given the copyright. But this was the world's first, that an AI supported work or AI generated work is given copyright to the person, the human who was behind the act. There were similar incidents like this one, Zarya of the Dawn. It was created by Kristina Kashinova, right? This was refused by the courts because this is AI generated story. And this one, another work of art created by AI, was refused copyrights by the US. But these are both US cases. In both the instances, it was not given, the copyrights are not given to the person who claimed it. Here it was claimed for the machine. The court said no. So, but Chinese decision is somewhat different here. Take a look at it. This is decided by the China Internet Court, part of the Supreme Court of China. Take a reading, please. Intellectual creations. It should create the intellectual input and the contribution of the human beings. Here, in this case, the court said that there were nearly 30 prompts, 120 negative prompts. That means the commands given to the AI system, right? That means human intervention, human ideas, human instructions, human orders, human suggestions, right? So that sort of inputs, the court said, should be considered as, intellectual input or contributions. So finally AI responded to the commands and created the image, and so the court stated that this work has to be created as an intellectual creation of the artist. But it's a challenging case. A case like this has never been tried or attempted in a foreign land. So we'll see how the world react to this unique case. It was just recently heard and decided in China. So far, the AI supported work is not considered as intellectual property. So that's the standing as it's kind of stands today. You can check these cases, right? The links are given. I'll add up the links as well. But look at this one. Can you plagiarize yourself? Few years back, the singer Taylor Swift has had a shock when she found out that her record label company was bought by another company. With it, she lost the right to all her original songs. Normally, record companies have rights to the songs. So when another person bought the record company to which Taylor Swift was singing for, she lost the touch with a link to her original works. Then what did she do? She started singing the songs again. Can the company that bought her original songs refused or stopped Taylor Swift from singing her original songs again? Answer is no. This case would be one thing. You can't plagiarize yourself. The case is John Fogerty versus John Fogerty. Check the story. He's a musician, rather famous one, songwriter as well. And earlier he was a band member of the Creedence Clearwater Revival, CCR, 1980s band, rock band. But then he left the group and started solo. Normally, most of the singers do that, right? Originally, you're part of a band and then you leave and create a solo career. Yeah, okay. Then what did he do? So he released a song called The Old Man Down the Road. But then the CCR, that means what? The group where he was a member of, took legal action against Fogerty, telling that this particular song, Old Man Down the Road, is a copy or the plagiarizing of Run Through the Jungle sung by CCR. But in the case, the John Fogerty said, look, Run Through the Jungle was my song. I was member of the group and I created the song. So don't I have the right to use some of the music used by me for my own work? The judge sided with the Fogerty and then said, you can't plagiarize yourself, effectively ending any further discussion as to whether or not he plagiarized the work. So this will have repercussions, right? Especially in the world of art, in movies, in drama, in music, the people work together, people part ways, people leave to start solo careers. So what you created as part of a team may be utilized by you individually after this particular case. So it's a big change. So I mean, even if you have signed a contract telling that you would be kind of the band will have the right to the songs and all, but the individual creativity coming under intellectual property could still carry with you the moral rights, we call it. So when you create your own music separately, so the original work that you did for someone else may be used by you, right, for your own work as well, once you leave the particular group, once you leave the particular earlier organization. So this is a big change, and you can't plagiarize yourself. We can plagiarize others, but let's say my work, which was part and parcel of a work that was done with another group of people, can I use at least a bit of part or all of it for my own separate work once I leave them? Well, this case says yes, it can be done.